There are many statutes out there that deal with unified and shared services, and this is where states are looking to address how do we prevent a parent from having to sign multiple disclosures and redisclosure consent formats throughout the whole process. We can get into a paper nightmare here. So how do we look to develop a consolidated redisclosure statute or a consolidated redisclosure process that allows us to address the juvenile and, in effect, tick off the different types of services or activities that we will be collecting information on the juvenile about over time and then moving it forward. Many states, some of them are shown here, Texas, Oregon, North Carolina, have looked to develop some shared statutes. And these shared statutes or federal bills or state bills or policies have looked at amending existing regulations in one way or another to allow for sharing of data. Some states, like Texas, look to their family code and tried to establish an internal protocol where they were looking to share and allow redisclosure of data to other juvenile justice service providers to efficiently and promptly process and administer services to the juveniles. Other states like Oregon and North Carolina looked more specifically to certain types of records or certain types of children. So they looked at children who were subject to child welfare, abuse and neglect areas, or social services areas and said, we really need to get as much information about this juvenile that is specific to the juvenile situation, whether it be health, educational, substance abuse, or other information, to be able to effectively attend to, protect, and control and ensure the child's welfare. Other states, such as California, have looked more at the areas of the juvenile as to where is the juvenile in the process. Is the juvenile now under or subject to court orders, such as under probation, where conditions can be imposed about disclosing and redisclosing the information? Or is the child in a treatment facility, be it medical, psychological, behavioral, where we need to maintain the continuity of the treatment by sharing the data? Some other states, such as Connecticut and Kentucky, have looked to provide redisclosure on a court-ordered basis and have put the onus upon specific agencies and said, you know, these are the situations where we need to share. It doesn't matter if the kid's in a facility or the kid's under an informal adjustment. This is the situational or the scenario, the use case-based situation. In most instances, though, we go back to the consent form. How was consent initially provided to disclose the data? And did that consent form include any definition of limitations or policies regarding redisclosure? A unified or shared services redisclosure consent form will provide options in the future and will, as a general rule, allow states to define exceptions from typical situations and define anecdotally particular situations where shared services are more than likely going to occur and more than likely in the future we are going to need redisclosure. In those instances, what we need to look at is not only what's on the consent form, but we need to look at some of the reasons why data would be disclosed and redisclosed. In-house consultation is one that happens a lot with medical and substance abuse, where persons directly involved in the case, multiple psychologists, psychiatrists, doctors at a particular institution or agency may be involved in the care, the assessment, the counseling of the child. Each time there is a consultation by one of the professionals in this agency, do we need to re-sign a form? And the answer is no, because we are dealing with a single agency. The consent was to the agency. We look at emergency situations and crises. It's very easy to claim it's an emergency, but HIPAA and FERPA and Part 2 specifically look to bona fide, immediate emergencies, such as an auto accident, such as a child going into shock, such as a reaction to a drug, or a situation where there is harm and immediate care needs to be happening. Court-ordered evaluation is another one. Evaluation is a word that everyone uses, but if it's a court-ordered evaluation, then specifically that evaluation on that consent form must define the specifics of what's going to be involved. Keywords to look for are shared consultative, treatment providers, interagency collaboration, court-ordered, emergency. And of course, we need to make sure that we understand those specific educational, institutional, medical, and substance abuse areas where there are exceptions, such as HIV, such as danger to self, such as threat situations. When we look at danger to others, this is one area where we need to examine just one situation. And this is something that will be raised more often as more court situations occur following terrorist incidents or specific incidents where there was some indication in the past that there may be a problem in the future. The incident we look at is Tarasoff versus the Regents of the University of California at Berkeley. In this situation, a counselor at a university counseling center was seeing a male client who was obsessed with Tatiana Tarasoff, a female student at the university. When the therapist became aware that the client was capable of physically harming Ms. Tarasoff, he contacted the police and warned them of the potential danger. The client did murder Ms. Tarasoff, and her parents sued, claiming wrongful death, asserting that the therapist should have warned Ms. Tarasoff directly. The suit was decided in Tarasoff's favor, and in the decision, the court stated that the protected privilege, confidentiality, ends where the peril to public safety begins. So in this instance, the court spelled out specifically that when the following conditions are met, a special relationship with the counselor-client exists, counselor-client, physician-patient, psychiatrist-patient, when the reasonable prediction of a conduct that constitutes a threat to another exists, there was a definite indication that there was going to be a problem. When the client possesses the means to carry out the threat, and when there is a defined and foreseeable victim, the mental health professional, in this case, is required to take reasonable action defined as notifying authorities of the threat, notifying the potential victim of the threat. In the years since Tarasoff, we've seen a number of situations where mental health officials, medical officials, and public health officials, as well as psychiatrists, psychologists, and educational counselors, have been challenged as to whether or not their opinions, professional or otherwise, related enough information forward to prevent situations from occurring. We need to continue to look at this and make the decision that we understand what reasonably assessed means, what reasonable predictions mean, what legitimate authority means, and what is the level of knowledge, skill, and care that we expect these officials to possess and to provide and communicate when there is an instance where juvenile justice assessment could result in a threat, and therefore redisclosure should happen. So to summarize, when we're looking at redisclosure, there's a couple things we need to do. We need to understand that redisclosure is not automatically authorized by initial consent. That HIPAA and FERPA specifically have rules regarding redisclosure when it relates to school and medical information. That substance abuse treatment records, mental health records, and psychiatric reports, particularly those covered under Part 2, have limited disclosure and even more restrictive redisclosure limitations. While there are exemptions defined in state and federal law, and these include emergencies and health and safety positions, these are exemptions and not the general rule. We need to make sure that we understand the new FERPA provisions as they come out, as well as new HIPAA and other federal and state laws that address redisclosure and disclosure and expand the ability to disclose or redisclose data to cover the new juvenile justice collaboratives, interagency treatment and assessment groups that are being established at the state and local level in many states. This would include juvenile justice assessment centers. We need to also look to specific care units such as child welfare, court-ordered disclosures, and juvenile justice collaboratives to understand what the specific policies they have regarding redisclosure of any and all data, and are there legal penalties and fines that can be imposed. We also need to make sure, and this is probably one of the most important areas, we need to make sure that we've trained the agency and collaborative staff who are dealing with juveniles and are responsible for completing the consent forms or receiving or requesting the data on the juveniles, whether it's in initial disclosure or a redisclosure. We need to make sure that they understand and are trained on what the regulations are, what can happen, what can't happen. And we need to make sure that the consent forms that are produced for parents and guardians, as well as for minors in the case of substance abuse and some mental health care, have the right disclaimers regarding redisclosure, and that these disclaimers are written in a language that parents, guardians, and children can understand. In short, we need to make sure that we do as good a job as we can about communicating the data that's out there, understanding the laws, and training our people so that we can continue to provide juvenile justice information sharing in a manner in which it supports juvenile justice and helps to protect and process our children, youth, and juveniles through the system in a regular, normal, and organized fashion that protects their safety, their privacy, and their persons throughout the process. Further references and information on this briefing are available, and we suggest you contact the National Information Sharing Initiative at info@juvenileis.org. Thank you for listening to this presentation, and we hope to be speaking with you soon about redisclosure, other areas